Print, email, Facebook, Twitter. More fact check. Was the latest dual citizenship decision absolutely obvious and clear? The claim the May 9th decision of the High Court in relation to the dual citizenship of Labour's Katy Gallagher has led to the departure of 5 politicians from Parliament, 4 of whom were from the Labour Party. Back in November 2017, opposition leader Bill Shorten effectively gave a rolled gold guarantee that no Labour MP or senator would be caught up in the dual citizenship issue. He now says that he relied on the best legal advice at the time, and the court's latest decision has set a new standard. Prime Minister Malcolm Turnbull claims that the outcome for these MPs was never in doubt given the High Court's October 2017 decision in relation to the eligibility of Coalition Senator Matt Canavan and former Deputy Prime Minister Barnaby Joyce, among others. In response to the decision, at a media conference, Mr. Turnbull said, "It has been absolutely obvious and clear, at least since last October when the High Court gave its decision in the Canavan and Joyce cases. It's been obvious that those people were ineligible to sit in the House of Representatives." Is this really the case? MIT ABC Fact Check investigates. The verdict. The Prime Minister's claim is exaggerated. In its May 9th decision, the High Court built on its earlier reasoning and has now made clear that a political candidate's renunciation of foreign citizenship needs to be complete before nomination, unless the foreign country's laws place irremediable obstacles in the way. Media player, space to play, M to mute, left and right to seek, 00:001:05, only then does the question of whether that candidate has taken all reasonable steps come into play. Lawyers for the 5 politicians had argued that it was sufficient for a candidate to have taken all reasonable steps within their power to renounce before nomination, regardless of the response by officials of the foreign country. The May 9th decision may have been the more likely outcome given the High Court's strict interpretation of Section 44 in last year's the Canavan case. But based on Fact Check's own analysis and consideration of the views of 3 eminent legal experts, there remained the possibility that the court would rule otherwise. This was acknowledged in the government's own legal advice. Until May 9th, uncertainty remained. The fates of politicians who had taken all reasonable steps to renounce British citizenship but were delayed by UK Home Office processes were not absolutely obvious and clear. Who was involved? Section 44I of the Australian Constitution deals with the disqualification of members who hold citizenship of another country or have an allegiance to a foreign power. It states that any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen or entitled to the rights or privileges of a subject or a citizen of a foreign power, shall be incapable of being chosen or of sitting as a senator or a member of the House of Representatives. Candidates in the 2016 federal election needed to have satisfied the requirements of Section 44 of the Constitution by the closing date of nominations, which was June 9, 2016. 4 out of the 5 recently resigned politicians faced similar issues, having applied to renounce their British citizenship before June 9, but not receiving confirmation until later. Former Senator Katy Gallagher entered the Senate in March 2015 to fill the vacancy caused by the resignation of former Senator Kate Lundy. She was subsequently elected in the July 2016 double dissolution election. She held British citizenship by descent from her father, and indeed was a dual national during her initial period in the Senate. Although Ms. Gallagher was a member of the ACT Legislative Assembly between 2001 and 2014, ACT law does not exclude dual citizens from membership. Ms. Gallagher sent a renunciation form to the UK Home Office on April 20, 2016 and some further documents in July 2016. Her renunciation was registered on August 16, 2016. Rebecca Sharkey held British citizenship from birth in the United Kingdom. Ms. Sharkey sent a renunciation form to the Home Office on April 19, 2016 and a further document in June 2016. Her renunciation was registered on June 29, 2016. Josh Wilson held British citizenship from birth in the UK. Mr. Wilson sent a renunciation form to the Home Office on May 13, 2016, and his renunciation was registered on June 24, 2016. Justine Kay held British citizenship by descent from her father. Ms. Kay sent a renunciation form to the UK Home Office on May 13, 2016, and it was registered on July 11, 2016. Former Labour MP Susan Lamb's case was different. As detailed in an earlier fact-check, she continued to be a British citizen while in Parliament. Ms. Lamb had sent a renunciation application to the Home Office on May 24, 2016 and later provided further documents, but it was ultimately rejected on August 10, 2016. Ms. Lamb's position prior to the recent decision was that she could not complete the renunciation process without a copy of her parents' marriage certificate, which she was unable to obtain. Media player, space to play, M to mute, left and right to seek, 00:007:4100:007:41 on February 7, 2018, Ms. Lamb told Parliament that 3 independent barristers, including a retired Justice of the Federal Court of Australia, have resoundingly agreed that I took all reasonable steps to renounce my citizenship. I remain confident I took all reasonable steps to renounce my citizenship, she said, after the High Court's decision on May 9. Ms. Lamb made another attempt to renounce her British citizenship, and it was apparently processed and registered 3 business days later. I do appreciate that last time around, they required Susan Lamb's parents' marriage certificate, Mr. Shorten told the media on May 15, 2018. This time round they didn't. What had the High Court said before? The principles around Section 44 of the Constitution and dual citizenship have been well canvassed by fact-check and other media outlets since July 2017, when former Greens Senator Scott Ludlam became the first of a series of politicians to resign over citizenship issues. There were 5 separate written reasons handed down in the 1992 Sykes v. Cleary case. Chief Justice Anthony Mason and Justices John Toohey and Michael McHugh found that Section 44I should not be read to give unqualified effect to a foreign country's laws around citizenship. To do so might well result in the disqualification of Australian citizens on whom there was imposed involuntarily by operation of foreign law a continuing foreign nationality, notwithstanding that they had taken reasonable steps to renounce that foreign nationality. Justice Darrell Dawson introduced the concept of citizens being irremediably incapable of entering Parliament. S.44I should not be given a construction that would unreasonably result in some Australian citizens being irremediably incapable of being elected. Some 25 years later, in October 2017, the High Court in the Canavan case adopted the irremediable terminology. The focus of concern of the majority in Sykes v. Cleary is upon the impediment posed by foreign law to an Australian citizen securing a release from foreign citizenship notwithstanding reasonable steps on his or her part to sever the foreign attachment. A person who, at the time that he or she nominates for election, retains the status of subject or citizen of a foreign power will be disqualified by reason of S.44I, except where the operation of the foreign law is contrary to the constitutional imperative that an Australian citizen not be irremediably prevented by foreign law from participation in representative government, where it can be demonstrated that the person has taken all steps that are reasonably required by the foreign law to renounce his or her citizenship and within his or her power, the constitutional imperative is engaged. Did the last sentence above leave some ambiguity? In the Gallagher case, the court made clear that an exception for a person who had taken reasonable steps to renounce that foreign nationality is only available where a foreign law operates irremediably to prevent an Australian citizen from participation. The court found, a foreign law will not irremediably prevent an Australian citizen from renouncing his or her citizenship simply by requiring that particular steps be taken to achieve it. So for a foreign law to meet the description in the Canavan and Sykes v. Cleary decisions, it must present something of an insurmountable obstacle, such as a requirement with which compliance is not possible. What did the lawyers say before the decision? Mr. Wilson, Ms. Kay and Ms. Sharkey had attached legal advice from senior barristers to their statements in relation to citizenship lodged with the House of Representatives that supported their positions. Mr. Wilson and Ms. Kay attached opinions from former federal court judge Ray Finkelstein QC and barrister Simona Gori, in the advice, dated November 8, 2016. Attached to Ms. Kay's declaration, Mr. Finkelstein and Ms. Gorey stated, "The High Court confirmed that a candidate would not be incapable, by reason of Section 44 of the Constitution, of being elected to either House of Parliament on the basis that he or she is a foreign citizen provided the candidate had taken reasonable steps to announce that citizenship." We note that several constitutional law academics have been reported as expressing the view that it is uncertain whether taking all reasonable steps is sufficient to overcome the S44I disqualification. We do not agree. Media player, space to play, M to mute, left and right to seek, 00:0003:400003:40 Mr. Finkelstein and Ms. Gorey's advice, dated November 13, 2017. Attached to Mr. Wilson's declaration similarly stated, despite the fact that at the time of his nomination he was still a British citizen, he had, at that time, taken not only all reasonable steps to renounce his British citizenship, he had taken all the steps that were required under the relevant British laws. In reaching this conclusion, we appreciate that a view has been expressed by some commentators and some eminent constitutional lawyers that the Sykes v. Cleary exception, as explained in Re Canavan, only arises where a foreign law in effect prevents an Australian citizen from renouncing his or her foreign citizenship. In that event, as such a foreign law would be inconsistent with Australia's constitutional imperative, the foreign law would not be given effect. Our reading of both Sykes v. Cleary and Re Canavan is to a different effect. WE simply cannot accept that they require more of a candidate than to take reasonable steps to comply with the foreign state's requirements for the renunciation of that foreign state's citizenship. Ms. Sharkey attached a legal opinion of Peter Hanks QC, who has published several books on Australian constitutional law. In his opinion, Mr. Hanks stated, "It is inconsistent with Re Canavan to insist that the processes of United Kingdom law, including the drawn-out processes used to administer that law, will control the date at which an Australian citizen's renunciation becomes effective." Media player, space to play, M to mute, left and right to seek, 00:001:1300:0001:13 What was the government's position before the decision? Fact check does not have access to internal legal advice provided to the government or the Federal Attorney General on the implications of the Canavan decision. However, in November 2017 the government released an advice prepared by David Bennett QC, who was the Commonwealth Solicitor General for 10 years from 1998. Mr. Bennett was asked to advise on whether Ms. Kay, Ms. Lam and Ms. Sharkey were caught by Section 44 and took the view that all three members were so disqualified, but this view cannot be expressed with absolute certainty. Mr. Bennett accurately predicted the High Court's reasoning in the Gallagher case, stating, "A candidate who holds foreign citizenship at the time of his or her nomination for election is disqualified unless the relevant foreign law irremediably prevents the candidate from announcing that citizenship. Where a person is irremediably prevented from announcing his or her foreign citizenship, it will be sufficient for the candidate to take all steps that are reasonably required by the foreign law and which are within the candidate's power. A foreign law does not irredeemably prevent someone from standing for election to the Australian Parliament if it provides a clear, knowable path to renunciation." However, Mr. Bennett also added that this was a developing area of constitutional law. It remains a remote possibility that the High Court will retreat from the strict approach by admitting an exception. For this reason my conclusion cannot be expressed with absolute certainty. Re Gallagher, 2018, HCA 17, the 9th of May 2018, document pages notes text zoom close previous for next P1 loading P2 loading P3 loading Re Gallagher, 2018, HCA 17, the 9th of May 2018, contents original document, PDF, related article contributed by ABC News, Australian Broadcasting Corporation page note 1 of 20. To print the document, click the original document link to open the original PDF. At this time it is not possible to print the document with annotations. What do the experts say? On November 30, 2017, before the Gallagher decision, constitutional law professor Anne Toomey of the University of Sydney gave a lecture at Parliament House. There continue to be ambiguities and uncertainties that will have to be dealt with by the courts before a reasonably certain set of rules can be developed. Professor Toomey said. In her accompanying paper, Professor Toomey wrote, despite the dueling opinions of David Bennett QC for the Commonwealth and Peter Hanks QC for the Labour Party, expressing adamant views on opposite sides, the reality is that the issue of the applicability of the reasonable steps test was left unclear by the Court of Disputed Returns in re Canavan. On the one hand, when the taking of reasonable steps was recognized as the relevant test in re Canavan, it was in the context of the constitutional imperative to avoid the irremediable exclusion of citizens from being capable of election to Parliament. On the other hand, the High Court in re Canavan upheld the authority of the majority judgment in Sykes v Cleary in circumstances where that court appeared to accept that it was enough that a candidate take all reasonable steps to renounce his or her citizenship, where renunciation is permitted or is a matter of discretion by the appropriate minister. After the Gallagher decision, Professor Toomey told Fact Check, the High Court in re Canavan certainly raised a red flag about the popularly held view of the reasonable steps test. The court tied the test to the constitutional imperative that Australian citizens not be irremediably prevented from standing for Parliament. At that stage it would have been prudent for previous advice to have been reconsidered. But it was still possible that the High Court might take a broader view of the test, given that in re Canavan it had also upheld the authority of Sykes v Cleary, which did seem to apply the reasonable steps test in circumstances where the candidates were faced with no irremediable impediment to renunciation. Graham Moore, a professor of law at the University of Queensland, tells Fact Check that the outcome of the Gallagher case wasn't absolutely obvious. In the Canavan case last year, the court did not have to decide whether all reasonable steps before the election was called were insufficient if the overseas bureaucracy's processing caused delays, he says. So the issue was arguable, though we did have reason to believe the court would continue down a hardline path. Kim Rubenstein, a professor of law at the Australian National University, says, before the re Gallagher decision, it was reasonable to take a view, based on the earlier decisions, that if you had done all in your power to renounce your other citizenship before you nominated, then you would not be ineligible under Section 44I. The court has now effectively found that it is in your power to find out how long it takes for the other country to process your citizenship renunciation, and a candidate has to build it into their timing for nomination. Sources: Bill Shorten, 730 interview, May 10, 2018. Rebecca Sharkey, statement in relation to citizenship. Josh Wilson, statement in relation to citizenship. Justine Kay, statement in relation to citizenship. Katie Gallagher, statement in relation to citizenship. Susan Lamb, statement to Parliament, February 7, 2018. Matthew Doran, ABC News. Former Labour MP Susan Lamb renounces British citizenship, months after emotional speech to Parliament. May 15, 2018. Re Gallagher, 2018, HCA 17. Sykes v Cleary, 1992, 176. CLR 77. Re Canavan, 2017, HCA 45. and Toomey, Section 44 of the Constitution. What have we learned and what problems do we still face? November 30, 2017. And Toomey, A. Gallagher, Inconsistency, Imperatives and Irremediable Impediments, May 28, 2018.